Today, I would like to talk about the current issue regarding the separation of the investigation power and the prosecution powers. In Korea, the prosecutor's office has the kind of combined power, which include the investigation and prosecution as well. And therefore, the power of the prosecutors is very strong compared with the other countries, the power. And therefore, in terms of the efficiency, it has merit, but on the other hand, in terms of the protection of the human rights, I think there is some the possibility of the abuse of such a very strong power, which include both investigation and prosecution as well. And therefore, currently we are very controversial issues. This is very controversial issues, and the current government is trying to reform the legal system of the prosecutor's office, and now, but there are some debates. But in my personal opinion, the separation of the investigation and the prosecution is inevitable. Otherwise, maybe it can be abused. So anyhow, just the separation of power is very essential. Even in the digital era. In digital era, when every process will be transparent and also open as well, and therefore the too strong power of the prosecutor's office is not desirable, and therefore there may be some kind of check and balance. But so far it's like the prosecutor office has contributed the establishment of the human rights, but still just we have some concern about the possibility of abuse of prosecutors the strong power, and at this stage I think the separation of the prosecutor's power should be enacted. It means like through the legislations, the separation of the such strong power will be inevitable. And in the same context, the power of the judge should be adjusted. In the United States, the fact finder will belong to the jury rather than the judge. The application of the law belongs to the judge. In Korea, just the judge have very strong power, which include fact finding and also application of the law. And in the even in the judicial proceeding, the check and balance theory will be applied. Therefore, we should adopt the jury system from the Anglo-American legal system. Otherwise, the power of a judge is too strong, and also there is possibility of abuse. Unlike the German legal systems, we do not have any check and balance about the judicial power. In Germany, the Constitutional Court will have a power to review whether or not any violation of the constitutional law in the legal proceeding, in the judicial proceeding, was made. And in Korea, such kind of a review process is not permitted. In the constitutional law, constitutional court law, there is some kind of is express provision that judicial review by the constitutional court on the judicial proceeding is not allowed. And I think that is a problem. Such kind of provision should be deleted. And also, therefore, we should establish the judicial review power by the constitutional court. Should be enacted, which means we cannot exclude the possibility that some human rights will be violated in the legal proceeding, such as in the judicial proceedings. And therefore, we need such kind of check and balance the legal system. And therefore, just to wrap up, in the prosecutor's office, in the means like how can I say, in the prosecution process, we just divide in two parts: one investigation and the prosecutions, and the separation of the authority which govern the investigation or govern the prosecutions, they should be separated. And through the check and balance, it should be should sustain balance. Otherwise, maybe we cannot exclude the possibility that any human rights will be violated. But in the process, maybe it is very rare case to find out the violation of the human rights in the quasi-judicial proceedings. But anyhow, I'm talking about the possibilities, and therefore we need such kind of enactment which separate prosecuting the power from the investigating the power. And also in the legal systems, the power of a judge should be checked and balanced, and the fact finding should belong to the jury rather than the judge. And but in that case also, judge who is expert on the law will have some kind of instruction or on the certain issues to the jury in order to help the jury find out is correct or is like exact fact, relevant fact under the how can I say, the eye of the law. only just the judge should take care of the application of law, interpretation of the law. And I guess nowadays, like the fact is sometimes it's complicated, and some layman cannot find out exact the fact, because some fact needs some kind of expert knowledge and experience. But as you may be aware, the judge sometimes have some difficulties in finding out the delicate fact, because he's not used to such kind of business world, and therefore to find out the exact relevant fact, we should utilize the juries who is used to, or just or have some knowledge or experience. Maybe, any lay person who do not have any knowledge about such kind of business world will be the jury, but a kind of some how can I say some. But I think it is not desirable. Just it left the fact finding on the judge himself. Maybe one or two judges will not be enough. Maybe several jury will have a more right persons to exactly find out the relevant fact, and that is very important. In this light, our judicial system should be reformed, and this is right time, because we should have a strength in the digital era, and in digital era by itself has some characteristics, which means like any activities will be more transparent or open than before. And therefore, I think that the power of the prosecutor's office or some kind of judicial power should be, checked and balanced. Otherwise, it can be desirable. And we just, more emphasis on putting the energy on the more creative area. And in that regard, I think the judicial reform is inevitable and is very necessary. Okay.